Urgent call for international attention to inconsistencies in Taiwan's child protection practices. 2. Child Rights International Network, CRIN. Dear Sir, Madam. I am writing to raise urgent concerns about systemic inconsistencies in the way Taiwan's legal system addresses child sexual exploitation, and to request your attention and guidance in ensuring that Taiwan upholds the spirit and obligations of the Convention on the Rights of the Child, CRC. Taiwan is frequently recognized for its progress on human rights and gender equality. In official communications, the Taiwanese government has stated its commitment to protecting women and children from violence and exploitation, citing legal milestones such as the Domestic Violence Prevention Act and the Gender Equality Education Act. Furthermore, the legalization of same-sex marriage in 2019 has been presented internationally as a symbol of Taiwan's democratic maturity and human rights values. However, recent high-profile legal cases reveal a concerning gap between Taiwan's human rights declarations and judicial outcomes in cases involving child and adolescent sexual exploitation, especially when the perpetrators are public figures or the victims are male adolescents. 3 representative cases. 1. Aaron Yan, Yan Yalun, Wu Geng-lin, Wu Bingru. A prominent male celebrity, Aaron Yan, was convicted in 2024 for actions involving a 16-year-old male victim. He filmed sexually explicit material during their relationship and the footage was later leaked. Despite the victim's minor status, the court granted Yan a 7-month prison sentence suspended for 3 years, citing factors including an undisclosed settlement and the defendant's public remorse. Media and segments of the public widely framed the incident as a private relationship gone wrong, downplaying the legal and ethical severity of adult-minor dynamics in sexual contexts. 2. Mickey Huang, Huang Zijiao, Huang Su Chao. Huang, a well-known TV host, was convicted of possessing 2,259 child sexual abuse images and videos, involving identifiable minors between the ages of 10 and 17. Despite the scale and duration of his collection, he received only an 8-month prison sentence with no probation, and some media commentary focused more on his fall from grace than the rights and harm done to victims. 3. Tainan District Court Case No. 114 SU 106 2025. A civilian man was caught entering a primary school restroom 8 times in one day to secretly film children, including a girl and 3 other minors, exposing their private body parts. Although the act was admitted, the court ruled that since there was no direct physical interaction or abuse of authority, it did not constitute sexual exploitation, resulting in a not guilty verdict. This decision was heavily criticized by legal scholars and advocacy groups, including the Garden of Hope Foundation and the Taiwan Association for Human Rights, but has not led to any legal reform or judicial accountability. Patterns and cultural context. These cases collectively expose a recurring issue in Taiwan's handling of child exploitation. Sexual exploitation involving male minors is often reframed as mutual relationships or personal matters. Public figures benefit from legal leniency and media narratives that shift focus away from the victims. Filming or possessing illicit materials involving children is not always prosecuted as a serious offense. Courts have shown a narrow interpretation of what constitutes sexual exploitation, particularly when physical coercion or authority abuse is not overtly present, ignoring digital or psychological power imbalances. This judicial culture contrasts starkly with Taiwan's public promotion of child protection and equality under international norms. These cases are not isolated. These 3 cases, each involving different levels of fame and public visibility, demonstrate a broader legal and cultural trend, that the rights of children, particularly in cases involving privacy, digital exploitation, and non-contact sexual offenses, are often inadequately protected. Taiwan has incorporated the UNCRC into domestic law, but these cases show a disconnect between its commitments and judicial practice. There is a need for revised legal definitions of sexual exploitation to include non-contact offenses such as voyeurism and the filming or possession of private sexual imagery of minors. Mandatory judicial training on digital age sexual offenses and the psychological harm to minors. Stronger public awareness campaigns to reinforce that child sexual exploitation is a human rights issue, not a personal or moral failing. Request for support and action. We respectfully urge your organization to 1. Monitor and document these cases as part of your review of Taiwan's compliance with child protection principles. 2. Engage in dialogue with Taiwanese authorities, urging them to align their legal interpretations and judicial training with international definitions of child sexual exploitation. 3. Encourage Taiwan to fully integrate General Comment No. 13 of the CRC on the right of the child to freedom from all forms of violence, particularly in cases involving digital abuse, power asymmetry, and non-contact forms of sexual harm. 4. Promote the need for gender and sexuality-sensitive protections that safeguard male victims and do not excuse adult behavior under the guise of same-sex relationships or celebrity status. Taiwan has made significant advancements in legal equality and gender rights. However, these cases show that further progress is essential in protecting minors from exploitation, regardless of the gender or fame of the perpetrator. We believe that international scrutiny and support can play a vital role in encouraging Taiwan to close the gap between its human rights declarations and its judicial outcomes. We thank you for your continued advocacy for the rights of all children and hope you will take this matter into consideration. Sincerely, Blackjack. Case Summary 1. Aaron Yan Wu Geng-lin Wu Bingru Criminal Case Number 112, Su Zi, Number 543, Shilin District Court, 2024. Background. Taiwanese entertainer Aaron Yan, real name Wu Geng-lin, later changed to Wu Bingru, was convicted for crimes involving sexual exploitation of a minor. At the time of the offense, the victim was 16 years old. Charges and verdict. 1. Filming a minor engaged in sexual activity without proper legal justification, violating Article 36(1) of the Child and Youth Sexual Exploitation Prevention Act. 2. Possession of such video material with the intent to distribute, violating Article 38(2) of the same act. 3. Additional violations under the Personal Data Protection Act and the Protection of Children and Youth Welfare and Rights Act. Despite the severity of the crimes, the court granted a suspended sentence of 7 months imprisonment with 3 years probation, due to post-factum mediation with the victim. Controversy. Yan later made public statements that many interpreted as targeting the victim and downplaying his responsibility, raising concerns of secondary victimization and public misunderstanding of child exploitation offenses. Page facing up. Case Summary 2. Mickey Huang aka Huang Su Chao Criminal Case Taipei District Court, 2024. Background. Prominent television host Huang Su Chao, Mickey Huang, was found guilty of possessing 2,259 child sexual exploitation materials (CSEM) involving at least 35 identifiable minors aged 10 to 17. Charges and verdict. Unlawful possession of child sexual exploitation material, under Article 38 of the Child and Youth Sexual Exploitation Prevention Act. Convicted and sentenced to 8 months in prison and a 100,000 new Taiwan dollars fine, probation was denied due to lack of remorse and denial during trial. Key factors. The court emphasized the scale of the offense and its contribution to demand for child pornography, thus sustaining harmful cycles of abuse. Huang initially confessed during investigation but later denied guilt in court, further aggravating sentencing. Page facing up. Case Summary 3. Tainan Elementary School Bathroom Case, Criminal Case No. 114, Su Zi, Number 106 Tainan District Court, 2025. Background. A man surnamed Shi entered an elementary school 8 times in one day and filmed children using the bathroom, capturing explicit images of minors' private parts. Charges and verdict. Prosecuted under Article 36(3) of the Child and Youth Sexual Exploitation Prevention Act for recording minors' private areas without consent. The court acquitted Shi, stating that because the children were not in a sexual activity or coerced interaction, the act did not meet the legal definition of sexual exploitation under current Taiwanese law. Public and NGO reactions. The verdict was met with strong criticism from women's and child rights organizations, e.g., Garden of Hope Foundation, Taipei Women's Rescue Foundation, who argued that filming children's private parts for personal arousal clearly constitutes sexual exploitation. The case sparked renewed calls for legal reform and better sensitivity training for judges in child protection issues.